SJC-12300, Commonwealth v. G. Save Sabree.
Mr. Sabree, do we have you on telephone?
Yes.
Okay, so good morning, and you have 10 minutes, and you may proceed. But please keep your voice up, speaking loud and clear.
Thank you. Good morning, Chief Justice and members of the court. If I may I read a brief statement of approximately 2 minutes before I begin?
You may.
This is an appeal from a jurisdictional violation of the Appellate Division of the Superior Court under General Law 278, Section 28B, where the actions taken by the petitioner's criminal sentencing on appeal violated his right to the substantive due process and equal protection of law under state and federal constitutions, against double jeopardy in sentencing under the Commonwealth General Common Law and same evidence rules, first by the trial court after conviction and a second time by the Appellate Division via restructuring of the petitioner's governing offenses and resentencing me to consecutive terms that have now shown to be more than a 44-year miscarriage of justice, entitling me to immediate release from unlawful confinement per Rule 9A1 of the Massachusetts Rules of Criminal Procedure and the court's common law case decisions per Morey versus the Commonwealth, Shabazz versus Commonwealth, and the Commonwealth versus Williams, the cases cited. More detailed in my brief, reply memorandum, Malua reply brief, and my supplemental memorandum, among other appellate claims. Thank you.
If I could ask you a question, this is Chief Justice Gantz, Mr. Sabree. Have you had a have you had a parole hearing yet? Are you eligible for parole?
I've been paroled twice, but never let out. First parole was in 1988 when in Lancaster pre-release in Lancaster, Mass. And they paroled me to my then consecutive terms of 6 to 10 years, which again should have been ran concurrent with the life term under the same evidence rules, and they never were. And I didn't find out about it, like I said, until approximately 18 months to 2 years ago. The second parole was in 2004, which I was given what I consider to be purgatory parole release conditions that the Department of Corrections wouldn't adhere to, and the parole board eventually ended up revocating the life parole for the second time.
And so you're presently, right now, serving your life term, correct?
Correct.
Anything else you wish to address to us with regard to this particular matter?
That's about it, Your Honor.
Okay. Well, thank you. Then I'll hear from Ms. Lewis. And if you would keep your voice up so Mr. Sabree can hear you as well.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. We're asking the court to affirm the single justice denial of the defendant's 211-3 petition in this case. The defendant does have another avenue of relief, and that is a Rule 30A motion for release from unlawful restraint. In addition to that, the defendant has not made a showing of a violation of a substantive right, as he was properly sentenced by the trial judge and again by the appellate division in accordance with the statute, the rape statute in effect at the time, with which allowed for a life sentence. And that was 265, Section 22. Again, the rape sentence that was in place at the time, and I have that cited in my brief. I would also just...
That was 1974 or 5?
1973 was the offense, and 1974 was his conviction. The rape statute was amended in 1974 after his conviction, but still it allowed for, it wasn't bifurcated at that time into aggravated rape and rape. It still allowed for the life sentence. It wasn't until 1980 that it was bifurcated into Section A and Section B.
Now, two questions. One
Yes.
is, I was trying to figure out what the underlying facts were of this case, but the appeals court opinion is rather spare.
Yes.
Can you give me some sense as to what the facts were of the case and what Mr. Sabree's role was in it?
Your Honor, I'm with you that I don't have as much of a sense of the facts. I will note, and it relied on in my brief, the appeals court opinion. We do not have a trial transcript. I was able to pull the Commonwealth's brief, which had a portion of the victim's testimony that's in the Commonwealth's appendix. I also recently did get a hold of the co-defendant, Stephen Nicholson's parole hearing decision, and that gave a better sense of the facts, which effectively was that the defendant, Mr. Sabree, and his two co-defendants forcibly entered a victim's apartment on Beacon Street, took turns raping her, I believe, on her bed. One of them had a gun. I am not aware of who that was, but in that, I'm relying on the parole board facts. The defendant was listed as one of the people who did engage in the rape of the victim. The defendant, in terms of his specific role, after things were taken from the victim and after the rape was completed, the defendant called a cab. A cab came and picked them up. And the cab driver apparently did testify that to that fact, and they were eventually apprehended. First Nicholson, the co-defendant, and then the defendant, and then the third co-defendant, King. I'm happy to provide that parole board decision.
No, that's more than we had before.
Okay.
Did all three get life plus sentences?
I believe so, yes. I know that let me say this. I know that Nicholson, who was before the parole board, the decision I'm relying on is from 2007, he did get a life sentence, I believe. I just looked on the parole board website. I believe he was recently paroled. The defendant was from what I can discern from parole board records, was paroled in 1988 to his consecutive sentences on the armed robbery and armed assault in a dwelling. He was discharged from those sentences and then returned to his life sentence for the rape. I believe he had a parole hearing in 2007. I wasn't able to get a hold of that decision, that his parole was denied, and I don't have anything since then. If your honors have any other further, if your honors have no further questions, the Commonwealth will rest on its brief.
All right,
Thank you.
Yes,
I'm not arguing my innocence or my guilt. I take full responsibility for my participation in these offenses.
right, I'm aware that,
I'm arguing my sentencing structure.
yes, no, I understand that. I was just trying to get some background with regard to the underlying facts. But I do understand that your claim is with regard to the actual sentence, and the issue before us is whether it's appropriately before us under 211.3, as opposed to your pursuing a Rule 30 appeal before a trial judge. Since Judge Roy has retired, it would be taken by a current Superior Court judge. So I think we understand that. Thank you, sir.